Former President Jacob Zuma could again face another contempt of court charge if he refuses to be examined by National Prosecuting Authority (NPA) appointed doctors, say legal experts. If Mr. Zuma refuses to allow an NPA-appointed doctor to examine him despite there being a court order that he do so, that his own lawyer agreed to, then he is again in contempt of a court order, criminal attorney Ulrich Roux told News 24. Now, the last time he acted in contempt of a court order, the Constitutional Court's ruling that he appear before the state capture inquiry, he was jailed for 15 months. So, he would be well advised to stop the nonsense, stop the delaying tactics, and just have an NPA-appointed doctor examine him. If his medical condition is such that he cannot stand trial, then any doctor would confirm that. Attorney Macbeth Nkoungwane has also questioned if Zuma could legally justify his refusal to be examined by an NPA-appointed doctor, because his refusal amounts to defying a lawful court order his own lawyers had agreed to. Zuma's lawyers were last month scheduled to begin arguing his application for a special plea, in which he contends the entire NPA was too biased to try him for corruption, and he should be acquitted of all the charges against him. That plea is now on hold after Zuma was hospitalized while serving a 15-month jail term for contempt. On the 9th of September, after receiving a confidential medical report from Zuma's military doctors, his lawyers will confirm whether or not they will seek a further postponement of the case against him. Earlier this month, and with the full agreement of Zuma's advocate, Dali Pofu, Pietermaritzburg High Court Judge Piet Koen ordered that the state may grant a medical practitioner of its choice to examine Mr. Zuma to assess his ability to stand trial for corruption and for that doctor to be a witness, if necessary. Advocate Wim Trengove, for the state, had told Koen it was in the interests of justice for such an order, which he said he could not imagine the defense opposing to be granted. Trengove stressed to Koen the power to grant such an order fell under the provisions of the Criminal Procedure Act, which allows a court to take steps to determine the fitness of an accused person to stand trial. Koen then asked Pofu if he had difficulty with the state seeking an order that its own doctors would examine Zuma, to which he responded, "Well, as I understand it, if the state has any issues with the report, then the state is entitled. Because, as I said, neither myself nor Mr. Trengove, unfortunately, are medical experts, so he would hardly be able to cross-examine anyone if he has not had access to his own medical team." Koen said, "Indeed, that is so. So, there's no difficulty with an order being granted in respect of those 3 paragraphs." Pofu then asked the judge to read out the 3 proposed orders he intended to make, which included a final order that the state might appoint its own doctor to examine Zuma, and, if necessary, be a witness. Once the judge had read those orders out, Pofu responded, "That should be fine." In these circumstances, Nkoungwane said, Zuma's refusal to now be examined by NPA doctors was seriously unusual behavior, which puts Advocate Dali Pofu and his team on a serious back foot, because it's unheard of that an agreement, which was made an order of the court, will be deviated from by a party, without them furnishing any reasons. He added, Zuma's conduct might lead to the impression that the former president was clutching at straws because he did not want the uncertainty over his health, which could have significant implications for his criminal trial to be resolved. JG Zuma Foundation spokesperson Muzwanil Manyi insisted it would be premature to suggest that Zuma might face another contempt charge as a result of his refusal to be examined by NPA doctors, given the state had yet to decide whether it was satisfied with the medical report compiled by the former president's military doctors. But he has not ruled out the possibility that, should Zuma be ordered to subject himself to an examination by an NPA doctor, he would take legal action to protect his constitutional rights. Many accused the state of second-guessing the medical report produced by the military doctors responsible for the former president's care, as well as the care of all other heads of state, by seeking to have him examined by their own doctors. He said, "All President Zuma says in all this is that because his name is involved, now all of a sudden somebody must think that now there are some shenanigans." Many told News 24 Zuma's military doctors had every right to be very aggrieved by the NPA's insistence its own doctors must be allowed to examine Zuma. This, he suggested, amounted to one arm of the state disbelieving another. They are saying it to the military doctors, "We don't believe you, your professional integrity means nothing," Maughan said. What nonsense is this? Is Mr. Maughan now also taking issue with the approach taken by Advocate Pofu in agreeing to a state-appointed doctor examining Mr. Zuma? It must also be noted that seeking a second opinion in medical matters is not unusual, especially when it is claimed that an emergency procedure is required for a condition that has existed for 18 months. Zuma's lead doctor, Brigadier General Mkebisa Mdutiwa, previously stated in court papers the former president had suffered from an undisclosed condition for 18 months. Mdutiwa said the medical treatment Zuma now required cannot be delayed any further, as it carries a significant risk to his life. The minimum proposed period of care is 6 months, during which periodic reports will be communicated to advise on the possible availability of any further engagements on your end, he added. The NPA refused to comment on the saga, saying it would only do so